Good afternoon, ladies and gentlemen of the media and, of course, our listening and viewing audience. Welcome to today's media conference for Thursday, 22nd March 2018. Today's conference will be officiated by two cabinet members, namely our Minister of Finance, the Honorable Colm Imbert, and our Attorney General, the Honorable Faris Al-Rawi. First up would be our Minister of Finance, Minister Imbert.
Okay. I'm happy to announce that this afternoon the Cabinet approved the implementation of the procurement phase for the construction of the new terminal building and associated work at the ANR Robinson International Airport in Tobago. What this project will involve is the construction of a brand new modern international standard terminal building with all the features that one would expect to be associated with a modern airport terminal, including loading bridges for international aircraft and all of the other features that you would expect in a modern airport building. In addition, a new road will be constructed to allow access to the new airport terminal building in Tobago from the Chauvin Road intersection with the Claude Noel Highway. For those of you who know Tobago, there is a busy intersection at the intersection of Chauvin Road and the Claude Noel Highway, Milford Road, and the new road will take its departure from that area and go directly to the new terminal building, which will be at the end of the runway. The existing terminal building in Tobago is at the beginning of the runway. For those of you who travel there, as you come off the aircraft, you go straight to the terminal building. The new terminal building is at the other end of the runway, and the access will take it from there up to the Chauvin Road, which will give direct and easy traffic flow to all parts of Tobago. In addition to the terminal building and the new access road, there will be additional parking and additional paving facilities at the airport to accommodate wide-bodied aircraft and to accommodate international aircraft. The deadline we have set for ourselves for this project, which is going to be done on a design, finance, construct, or build, own, lease transfer arrangement or BOLT arrangement. The deadline we have set for ourselves is that the contract must be awarded around August of this year, and construction must begin by the end of 2018. We have set ourselves a target to complete the terminal building and the associated work before the end of the year 2020. So if everything goes according to plan, a contractor will be on site in the third quarter of 2018. Construction will begin on the new airport terminal building and associated work in Tobago by the end of this year, 2018, and the new airport terminal and the new facilities would be open for business before the end of 2020. The estimated cost of the project is 500 million Trinidad and Tobago dollars, excluding the cost of land acquisition, because there would naturally be some land acquisition because of the fact that the new terminal building is at the other end of the runway, so there would be a requirement for some land acquisition. The project is going to be supervised by a committee comprising representatives of the Private-Public Partnership Unit of the Ministry of Finance, as well as representatives from the Ministry of Works and Transport, the Airports Authority, and the Tobago House of Assembly. The implementing entity would be the Airports Authority under the supervision of this airport project oversight committee. And we expect that when this is finished, something that has been long overdue in Tobago for many, many years will eventually become a reality. For so many years, so many governments have spoken about the need for a modern international airport terminal in Tobago. Well, this government is going to do it. Thank you.
Thank you, Minister Imbert. And now we'll have the Attorney General, the Honorable Faris Al-Rawi, address you.
Good afternoon, everyone, and good afternoon to Trinidad and Tobago. I come to report on the conclusion of work which we settled in the Parliament yesterday in the House of Representatives. For the benefit of the listening population, it's important to put into context the successful passage in the House of Representatives, now headed to the Senate, of what we refer to as the land package. The land package is a very critical collection of laws designed to treat with a new system of registration of title to land, passing through a new system of land adjudication, and involving a specialist tribunal. Very important for the people of Trinidad and Tobago is the understanding that this package of laws will deal with something referred to as certainty of title. It's going to give what we call indefeasible title. The government has recognized that the process of land ownership has been plagued with fraud, delay, and uncertainty. And in fact, this has been the case since our land laws started a recording system way back in 1874 and then in 1892. We have had a very archaic system of land registration. In particular, for the people in the island of Tobago, land title has been a disaster. And this is very important because land constitutes wealth and security. And many of our people, including people who are occupying and squatting on state land, many of our people find themselves in a position where they have been in occupation of family lands or state lands for the periods over 16 years for private lands and over 30 years for public lands, but that they cannot take those lands to the bank. They cannot pass on the lands. They cannot give it to their children. They cannot go and obtain a mortgage to build a home or to finance education. This, therefore, has been met with by a very deliberate exercise of bringing to life a package of laws which will allow us to commence an exercise beginning in the island of Tobago, where there is a declaration that is made, and then land surveyors from the government go out into the public domain and begin what is referred to as a demarcation exercise. Every square inch of land is brought into a new system of compulsory registration. If there are any disputes in relation to the land occupation, if persons are on state land and need to prove their title and how long they have been there to be considered as to whether they are entitled to that state land, and for your benefit, the law is that if you are on state land for over 30 years of uninterrupted and peaceful occupation, that you potentially have a claim for something called a vesting order, where you can ask for the land to be given to you. All of that is now capable in this new system of going through a land adjudication process under a tribunal. And what this means in very simple terms is that people now have the benefit of a state-funded exercise to determine their land entitlement. This is radically important for our country, but there are a few very important exceptions which I must alert the population to. First of all, in the state suits limitation legislation, we have included, as well as in the land adjudication system, that there can be no grant of state lands for certain categories of lands, environmentally protected lands, lands such as aquifers, lands which are national forests and declared that way, or environmentally sensitive areas, or lands required for certain public purposes. There are exceptions to utilization. But this system and mechanism is one which, of course, has yet to be settled by the Senate. After passage in the Senate, We expect to go on a proper public education program so that all of the understanding that is necessary for people to become accustomed to what the system will be, for what they should expect the process to look like. There will be a national education program, and we intend as a government to begin the exercise in the island of Tobago. This project is underwritten by financing which we have secured from the international fund managers at the IDB. We have secured an $8 million loan for the island of Tobago, and we have secured a $100 million facility for the island of Trinidad. We are marrying the information which exists in the land registry together with the Lands and Surveys Division, and we expect that at the end of this exercise, which will take years to get all of Trinidad and Tobago mapped out and properly settled, but at the end of this exercise, people will be in a materially better position for having a certain title and understanding of the wealth that they occupy. This is groundbreaking for our country. It meets with our manifesto promises to settle land titling issues in our country. It is designed to eradicate fraud. It is designed to have certainty, and we recommend that the population pay close attention to a very important step that we have made in the administration of our land resources and in the administration of our state. I thank you.
Thank you, Attorney General. We'll now invite a few questions from the media.
Attorney General Joe Brown from TV6 News report. I pose some questions on what you had just announced. I just wondered if you had an update on the announcement made by the Prime Minister last week in terms of instructing you to seek clarification from the court on the issue of sabbatical leave or the expectation of access by judges for sabbatical leave.
Sure. On the issue of the judicial interpretation of the issue as to whether there's a sabbatical leave in the judiciary, I can confirm that the legal proceedings inviting the court to make consideration of that issue are being settled at present. They are near completion. We expect to file in a matter of days, and the court will then be invited to consider directions in relation to the management of the matter and resolution of the issue.
For those of us who are not lawyers, is this something that can be appealed once there's a ruling, or is it just
Of course. What's going to court is a very neutral presentation of an issue. There is an issue as to whether there is a sabbatical leave. Has it been created? Is there an entitlement? These neutral issues are put forward. The court is invited to consider whether these matters exist or not, and what are the outcomes, etc. After the High Court comes up with its decision, of course there's a right of appeal to the Court of Appeal, and then there's a further right of appeal to the Privy Council. So this is not so much an issue of litigation where there are two polar positions or parties. What this really is a matter of judicial interpretation. So it's not expected that this should be a very long process.
Can I ask, during this period, is it that no one would be allowed, how would anybody who applies for sabbatical before the determination by the court is settled, how is that going to be treated?
Well, I don't want to speculate as to an issue that hasn't yet arisen, but I would think that prudence would dictate that whilst the court is engaged in an exercise on a live issue, that persons will be guided accordingly. Well, I can't sit in the mind or position. I can't sit in the mind or position of somebody who may be thinking of applying or not applying, so I won't speculate. But suffice it to say, there's a live issue before the court, and the standard routine is that whilst the court is engaged in an exercise of settling upon an issue, that there tends to be a freeze or a maintenance of the status quo. Again, I don't want to speculate on the issue.
Okay. Now, you said yesterday that you are on the verge of taking this matter to the court. Can we have the name of the attorneys that would be
The teams are being settled, and there's a fluidity in the teams that are going on. So I'm not in a position yet to advise on that full factor, but suffice it to say the Office of the Attorney General is settling the necessary proceedings.
Just jump in here while we're on the matter of the sabbatical. There's a perception out there that maybe the interpretation will not be sufficient, and I'll explain why I say that. Because we're looking at a matter holistically. We have an office holder applying to an institution in November of last year. He apparently got permission from the Office of the President in February, but in March, then other members of the institution were informed that this facility, the sabbatical leave, was available for them. So my question really is, we're not really looking at, yes, we are looking at the issue as to whether or not the sabbatical leave is legal, but what about the entire process followed? And the Prime Minister did say that this matter will be settled by the court using the law of the land. So I'm asking if the Office of the Attorney General was considering having judicial review on this matter, not just to finally say whether or not sabbatical is allowed or not, but the process used by this individual to access it. And when sabbatical came out in the public domain and there was uproar, the individual then attempted to access a certain amount of vacation leave.
Permit me to answer. I think I've got the gist of what you're saying. The straight answer is that we are not considering judicial review, because we are certainly not in a zone where one would want to enter into that prohibition of trying to judicially review the Office of the President. That's just not on. This is a very simple issue where the issue as to whether there's a sabbatical or not is going to the court for interpretation in the manner described by the Honourable Prime Minister, and we are confining ourselves to that approach.
Respect, Mr. Attorney General, it's not just the Office of the President, because the question has been asked in the public domain. Is it that the Chief Justice would grant himself permission and the President is just the one to appoint a replacement, or does the President okay?
Most respectfully, the run-up to your questions involve a lot of speculation and a lot of hearsay or anecdotal evidence and information. Yes, and what we propose to do is to act within the confines of addressing the issue. The proposal for the court to consider this issue is a very sharp and clear issue. The Honourable Prime Minister has spoken to it with certainty, and that is the course of action we intend to pursue.
Why are we on this issue? One thing you said yesterday that struck me, you said that the state, the Attorney General, is a party to this matter, and you said the Judicial and Legal Service Commission. Now, with all the press releases we had from the judiciary on this issue, I never saw the Judicial and Legal Service Commission mentioned at all.
It is the Sure. Okay. The issue of parties is always the first issue when you go to court. To go to court, you have to have locus, meaning that you have to have position in court. You have to have a legal right to be there. It isn't that anybody can just roll up into court. You have to have a reason to be there, and you have to have what we describe in laws to be locus. The locus is situated between the Attorney General's office, because the Attorney General under the Constitution, under Section 76 of the Constitution 2, carries out litigation, etc., in the name of the state for both civil and for criminal matters. So that's one party. The second constitutional construct is the Judicial and Legal Services Commission, which is the entity in law which manages issues concerning the judiciary. And therefore, those are the two parties that are apparent in law. And that's why we go there. It isn't because they were named or had a party or had a press conference or had a position. That's not it. It's that that is the entity. For example, the President himself, the Office of the President, doesn't go to court. The Attorney General will go to court on behalf of or in the name of the President. And you need look no further than the Marcia Ayers Caesar matter, where there was an interpretation requested by the court. Again, the Attorney General acted, and the Judicial and Legal Services acted. And the Attorney General in that matter represented also the interests of His Excellency the President. So these are just matters of law as to who the parties are.
It just seems as though they were being given a local standard, that they themselves...
Under the Constitution of Trinidad and Tobago, it is clearly set out how these arrangements work. Yes, please.
For those who might be wondering, was it the outgoing president, Mr. Carmona, before he left office, would have approved the vacation leave for the Chief Justice, or was it Justice Weeks after she was sworn in as the new president?
These are, let's just leave it in the zone of the matter is headed to court. There is certainty that is expected in the outcome of the court, and all issues will be dealt with there.
So the impression I have is the court is just going to decide whether or not sabbatical is legal or not.
And therefore, everything flows from that. Process, entitlement, approach, everything. So why not settle the crux? Is it day or night? Is that a chair or not? If it's a chair, can I sit on it? Should I have sat on it? I mean, let's just deal with this in a rhythm which makes sense and which is logical. The point is, we have a court that can decide upon an issue. After an issue is settled, all permutations and combinations can be answered because you've settled a matter of fact and law. And I think that that's the most reasonable approach to take in this scenario. Yes, please.
I'm sort of shifting now to this very tragic event in the Kwesi yesterday.
Yes.
Sadly, again, a woman, you know, what can I say? Are there any proposals for legislative changes to rein in such matters, perhaps in addition to social work being done out there?
Yeah, the answer is yes. Okay. I can tell you that there is a very hard-working, energized group which involves the Office of the Prime Minister, Gender Affairs Division, the Ministry of National Security, the Office of the Attorney General, and certain stakeholders in the private sector. And in fact, we have done a significant amount of work to treat with the gender-based violence issues in Trinidad and Tobago. As a matter of fact, just today at Cabinet, we dealt with the baseline study on gender-based violence in Trinidad and Tobago and the quantitative and qualitative studies around that. And we have very specific and targeted amendments that we are treating with. And in fact, we've been working on it for quite some time because we recognize that there was a lacuna in the process and in the law. I'll give you an example about that, I'll give you a few examples in relation to this. You will see that what we did in the arrangements for children as we treated with juvenile justice and reform measures which touch and concern the family and children division and amendments to the laws as to how we manage our children, that we encourage the Trinidad and Tobago Police Service to establish a child unit. That child unit is comprised of 169 officers. It didn't exist before. Similarly, mechanisms right now that national security is coordinating involve the establishment of domestic violence units, protection units, where there are mandated, dedicated officers, etc. At the Office of the Attorney General, we have, again by way of example, the creation of a Children's Attorney Division, where we have attorneys that act under the provisions of the law to provide the voice of the child issues and representation for children anytime they are arrested, detained, or brought to court, where the Solicitor General's division manages those things. Apart from those operational structures, obviously the probation officer's department, if there are issues to be inquired upon, social services delivery, all of those things are being coordinated from a practical point of view. The legislative approach is on top of all of that, because we do have a domestic violence protection regime in Trinidad and Tobago. We do have the common law to treat with assaults and battery, etc. We do have approaches for injunctions, etc. The question is, have we got it right? So we're working on a whole of issue approach, which is practical and also legislative, and we expect to be in the public domain on this issue very shortly.
Some authoritative figure about a month ago was on television saying that a suspect who is subject to a restraining order is, well, entitled to commit two infractions of it. No, I'm putting the word entitled, and only on the third time will he. Is that correct?
That is not true. Under protection orders and undertakings, under the domestic violence legislation in Trinidad and Tobago, there are two types of protections that you can obtain on an ex parte or one person going to court basis. And that's at the lowest level. One is where the court issues a protection order, or two, where the person against whom the order is sought, that is the aggressor, attends at court and gives an undertaking. The undertaking and the order are both strictly enforceable, and any breach of the undertaking or order results in action, arrest, and contempt of court if you take it along certain lines. So that three-strike position is certainly not the law in Trinidad and Tobago. The requirement here is that when people find themselves at risk or they believe that they're going to be subjected to this form of position, you have to step forward to the Trinidad and Tobago Police Service. You must also consider whether you wish to go for a protection order under the domestic violence legislation. Obviously, the Trinidad and Tobago Police Service must take these matters seriously. They are the first-line responders. They have the ability to call in the Social Services Division, the Probation Officers Division. Obviously, as we see in other jurisdictions, usually acts of domestic violence or reports of domestic violence involve a knock on the door by a policeman. You see it on television. There is no rational explanation as to why that doesn't prevail here. In fact, that is the obligation that officers act in accordance. Hence, the Commissioner of Police has a role to play in ensuring that the police act upon reports. The position of the judiciary and how the law treats with applications that are brought to court is a different point. But remember, the court process is often 2 steps away from the first responder. If you're in a domestic violence situation, if you apprehend that something is happening, your first port of call is the police. It may involve the Children's Authority if there are children involved in the situation. But the point is that the Trinidad and Tobago Police Service is the line of first response. The law steps in when you get to court, and that is an important aspect there. So there must be an awareness, a societal intolerance, a societal demand for action, and then the processes flow.
I mean, I'm going to broadening this a little bit to the social, because you're fantastic with the legislative. But in addition, you know, is there a need, has Cabinet discussed a need to really look into why this is happening? Because, you know, we can pass laws and so on, and we can call for enforcement and so on, but there is almost like a sociological...
Yes. The sociological positions, for instance, the document that I have in my hand here, this thick piece of documentation, is the baseline study on gender-based violence in Trinidad and Tobago. Obviously, we didn't do this in 2 days' time, or because of recent events. The Honorable Ayanna Webster Roy, as the Minister with responsibility into this, has taken a very passionate approach, as have I, as has the Minister of National Security himself and the Minister of Social Services, the Honorable Cherry Coburn. In this position, the government has been at work making sure that all of the metrics are in place. Because obviously, it makes little sense to treat with the end result alone. You have to go to the deeper core issues, and the government has been very busy as to its part in the several players that are in this game in ensuring that we've done the work. And it just happens by chance that I actually have this in my hand with me because Cabinet just dealt with it. And there's a massive amount of other work that the OPM and AG and Ministry of National Security and Social Services have in coordination, and we're about to take that to the stakeholders, because obviously civil society has a serious role to play, largely as an advocate against violence and an advocate for encouraging solution finding.
I mean, understood that a significant amount of work is being done. When will we start to see results, and what can we do in the meantime? What is the state doing in the meantime? Clearly there's a breakdown. I mean, you look at the numbers, 14 year to date is sort of consistent with the 52 women murdered in 2017. But we're seeing that the murders are becoming a little more brazen, out in the public now, and a lot more gruesome. We're seeing children being killed as well. What do we do in the meantime, and when are we going to start to see results?
Well, this we is a very good question. The we involves the entire society. Family, the first thing that you have to do is to ventilate an issue. People need to know facts. If you notice, we've taken an approach as a government to tell you the facts, be it a spotlight on energy, or a spotlight on the financing arrangements of Trinidad and Tobago, a spotlight on child marriage, a spotlight on preliminary inquiries on prisons conditions. We've taken an approach to ventilate issues, put it out there. What are the facts? That encourages that you should no longer stay silent. You can't get protection if you're silent. having the state have a certain monitoring approach to recognize situations where somebody may be at risk, be it in the school or you're noticing unusual patterns at work, etc., it means being your brother or sister's keeper. What's next? State services do exist. You've seen the ramp up and amplification of the work of the Children's Authority. You've seen structures at the Trinidad and Tobago Police Service, and you're seeing laws being treated with. So this issue is one that the whole of society must deal with. It is a collective issue. The state has a role to play, and the state is facilitating that role. To answer your question as to when we'll see a difference, as we begin to change culture in Trinidad and Tobago. I'll give you an example. Was it possible for Trinidad and Tobago to slow down on the roads? 6 speed guns helped with that situation, but it was enforcement of the law that managed to do that. That came about by detection. You had to detect the people. And therefore, if you are in a arrangement where one of your family members or friends are this victim of domestic violence, or you think they are at risk, there are hotlines, there are reports that you can make. You cannot stay silent and say, that's not my business. If we are serious as a country, it can't just be, well, what is the government doing? Each family member must take this as seriously as the person themselves.
Is the state doing enough?
The state can always do better.
And as a man, you know, it has been said, some of your ministers also commented saying that men can't deal with rejection. Reading about these crimes, reading about these murders, how do you feel as?
There's a phenomenon that's not spoken about in this country, but as a practitioner and as a member of parliament, I can tell you that there's gender-based violence. It's true to say that both sexes have difficulty with rejection, men and women. There are difficulties of abuse, with men being the subject of abuse. The savagery of a man abusing a woman is an intolerable situation. So I think that this is a multidimensional position. There may be abuse between, in the relationship with your child or with your nephew or niece. There's a hidden issue that was discovered and unearthed in the child marriage discussions of incest in certain parts of Trinidad and Tobago, unreported positions. We are ventilating issues and bringing them out into the open, but our society has to band together. Matters of awareness. As a martial artist myself, I've taught martial arts for many, many years and practiced it. It is important to introduce self-defense. In the Office of the Attorney General in our ministry, we introduce self-defense classes for the entire ministry. And many of our women participate in situational awareness and self-defense and encouragement, because it starts with self. So there are multiple forms of address that you have to approach in this issue, and it's very important that we take the issue seriously. It's not a one-of-society approach solution.
Part of that solution, looking at legislation, would allow persons to carry non-lethal weapons like masons.
We are looking at the non-lethal weapon issue, and I should tell you it's a good moment to introduce this. I have just completed the draft of the sex offenders registry. It is an amendment to the law specifically to treat with sex offenders, and I hope to bring it to the Law Revision Committee by next week to ask for consideration. And we're completing our stakeholder consultation right now, so we have also for introduction as an immediate position not only the consideration of non-lethal aspects, which we're gaining consultation finality over, but also on the sex offender side of it. That's going to become very important, because as you know, we have the DNA regulations in the Parliament for debate. Let me put this forward. We will be introducing into operation DNA laws, even though they've been on the books of Trinidad and Tobago for 17 years. And I can tell you we've already disaggregated every single sexual offense and whether there are DNA positions in relation to that, so that we can get those things fast-tracked.
You put some information out into social media yesterday concerning the leasing of aircraft from Liat. You said that it would be equivalent to, or cover the amount you would save in not using fuel on the ferries, I believe. Would you be able to give us an idea of what the cost of leasing those aircraft would be?
Well, I gave the cost yesterday in the Parliament.
You
weren't there?
Wasn't that Parliament yesterday?
All right, the lease cost is $560,000 US from the 19th of March to the 30th of April. And the revenue from the passengers would be almost the same amount. So that the revenue from the tickets for the persons who would fly on that particular aircraft is almost equivalent to the cost of the lease of the aircraft. And the ferries cost $10 million a month to operate, $2.5 million a week. So that even though it's not a nice situation, with the 2 ferries being out of service, that is saving the country $2.5 million a week. So that it's not a good thing, but it's a tremendous saving in terms of cost. So when you look at the fact that the aircraft, there's a cost attached to it, leasing an additional aircraft, putting on additional flights to Tobago, but that is balanced by the savings of not operating the ferries. So from a cost perspective, it is actually more economical to put on more flights on the air bridge than to operate the ferries. But that is not a situation that one should take in its simplest terms, because you must have sea transportation. That's an absolute essential necessity. So we need sea transportation. But I just wanted to debunk the story that we're spending $4 million Trinidad dollars to charter an aircraft and there's a tremendous burden on the treasury. It is not. The revenue from the passengers is $4 million for starters, and the savings on not operating the ferries could be $5 or $10 million. So from a revenue perspective, we're actually in the positive. But it's not a good situation from the fact that we do not have the level of service on the sea bridge that we should have and must have.
And on that note, could you give us an update concerning the transit of the Galleons Passage to Trinidad at this time?
I checked it about 10 minutes ago. It's traveled about 40% of the way from Yokohama in Japan to Honolulu in Hawaii. It has about 2,000 miles to travel to get to Honolulu. It's doing about 250 miles a day, so it should be in Honolulu, Hawaii in 8 days. Everything is going well. It's going at its design speed. The Lloyd's Register, the International Classification Society, approved a vessel plan, a voyage plan, to cross the Pacific Ocean. You know, there's some talk outside there that the vessel is not approved for ocean travel. Well, in this particular instance, the vessel got approval from Lloyd's Register to make that trans-Pacific voyage. And the Lloyd's specified that the vessel should not exceed 12 knots. So it's doing at about 11.6 knots across the Pacific, and it's comfortably making that every day. And there are no reports of any problems with the vessel of any kind whatsoever. You may have a little tweaking to do here and there, but we've been receiving reports and there are no major mechanical issues whatsoever. The vessel is performing exceedingly well, and it is well on its way to Hawaii and should be here at the end of April, barring unforeseen circumstances. Maybe out by a day or two. Yes.
In relation to the Tobago Airport and the land acquisition,
yes,
by the AG, there's always this question in Tobago of people living on property but not having proper title.
Yes.
In terms of compensation.
Yes.
What would be the position of the government if someone is on land around that area?
Okay, I faced this problem, or we faced it as a government when we did the interchange back in 2008, I think we did that. We had to acquire lands in the bamboo area, and there were different types of people there. There were people who had freehold property, owned in their own right, as private citizens. There were persons who had leases of state lands from the state, some valid, some expired. There were squatters, so that we had to treat each person differently. You compensate persons according to their ownership. So that persons who were squatters, what was done with them, they were compensated for the buildings that they were on, and they were also given alternative lands leased by the state. Persons who own their own land, it was valued and they were paid the value of the land. Persons who had a lease from the state, the value of the lease was calculated and they were compensated in that way. So there are many different approaches. It depends on what you encounter. In the Tobago scenario, in that particular area, we may very well find a lot of that land is freehold, owned by private individuals, and it will go through the normal land acquisition process of valuation and compensation. But if, on the other hand, there are persons who are squatting, they'll be compensated for the buildings, they may get assistance to relocate to another area, they may even get a lease of state lands. It will all be dealt with on a case-by-case basis. But this is not rocket science. It has been done before, and it was done very successfully when we constructed the interchange. We had multiple families to deal with multiple different issues and types of ownership.
Okay, we'll take one more question before we wrap up the media conference, please. Thank you.
The question of people who have used fake deeds to secure bail. This new legislation, would that weed out that whole problem?
Yes, it most definitely will. Now understand, this new law, package of laws that we're operationalizing, runs alongside two other systems of registration and land management. One is the Real Property Act, and one is the system of deed registration. We are about to bring to the LRC a very, very important proposal for amendment of the system of registration in Trinidad and Tobago, which is directly related to fraud. And it is directly related to following the money. We have improved the technological side at the registry. We should be in a position to move the South Key registry to the Richmond Street campus. At the end of June, we expect to be inside of there. We've updated our IT and technology, having brought on deck the failure that the last government left. We found a solution to that. We renewed the software management and positions. We did all the data backup. We've bettered the system with servers, etc. But this package on the registration of deeds, this law that we're bringing with, is a radically important piece of law to treat with fraud and follow the money.
One more question.
Excuse. The last major terminal project at an airport would have been at Piaco, and we know what happened with that in terms of cost overruns, inquiry, and so on. What assurances can you give taxpayers that this terminal project in Tobago would not find itself in the same position?
One of the safeguards is the methodology. This is a design, finance, construct, public-private partnership, so that the successful contractor will have to complete the design of the facility. We have preliminary designs, we have conceptual designs. We have located the terminal building where we wish it to go. We know where the new access road will go out to the Claude Noel Highway and so on. But the successful contractor will have the responsibility to complete the designs and complete the construction within the period, so that avoids the complaint that they were interfered with or they were delayed by the client. They are now responsible for both the design and the construction. And they take the risk because it's their own design that they are going to complete. So they can't blame the engineer, for example, for an imperfect design. They can't blame the engineer for not giving them instructions, because they, once the concept is approved, they now have the responsibility to complete the design and do the construction. So it's the approach we are using.
I have
one question. You want to ask two?
Please.
Well, go ahead.
It's concerning the Galleons Passage. Right now
Sure.
there's some skepticism in the public as to whether or not it will reach here on time. So one part of the question was, how long will it install in Cuba?
May I ask you a question? Where is that skepticism coming from? Because we are tracking the boat every 12 hours. We get a satellite feed every 12 hours giving us latitude and longitude. And I want to make a point. If I may get criticized for using this word, but if amateurs go on the internet and use a free vessel tracking site, what they don't realize is that the position they get
is 2 days behind time. So that if you go and use marine traffic, for example, or vessel finder, I see you nodding, so you know you go there and you use the free version of that vessel tracking site. You get a position as 2 or 3 days old. So for example, I saw a report in the newspapers about the vessel that it was now exiting Yokohama and traveling at 3 knots, when our real-time satellite had it almost 500 miles away from Japan, traveling at 11 knots. So I don't know where the skepticism is coming from, but the vessel is on time, is sailing comfortably, and as I said, it should be in Hawaii in 8 days' time. It then heads for the Panama Canal, and then the stop in Cuba is for 10 days. So if you add it all up, in 8 days by the end of this month, or the 1st of April, the vessel should be arriving at the Panama Canal, and then it will just take a few days after that to reach to Cuba. It stays in Cuba for 10 days, and then it comes from Cuba straight to Port of Spain. So that if all goes well, it should arrive at the end of April as we have scheduled. So I don't know where the skepticism is coming from, except from persons who, for some reason, don't want this vessel to arrive.
I'm not going to argue with you. I did look at those sites, but I also used the good old time is equal to distance over speed. I did use that. I did my own calculations here.
You have a satellite tracker?
No, but
with real-time information? I don't think you should do that. Could I ask? Go and pay for the correct version of the vessel tracking software, and you'll get it right away. But could I ask a question? Whether the vessel comes today, tomorrow, or the day after, there's accountability. Secondly, when it arrives, all of this debate will be over. So what is the difficulty in the Minister of Finance having gone the extra mile, because he shares the vessel location on a constant basis? This isn't an average Joe sharing the information. This is a cabinet minister who is tracking it using the licensed information paid for longitude and latitude. It's not anybody just giving you the information, and I don't mean that disrespectfully. So you're having full-fledged information sharing. I'm at a loss to understand what is the drama over whether it is at X longitude or Y latitude. And by the way, you have one more question. And that would be the last one. I'm afraid I have another appointment.
Please. So let's just say it doesn't get here before Easter. What contingency?
Before Easter? It's arriving at the end of April. Do you know when Holy Friday, Good Friday is, and Easter Monday? Wait. Let me clear this up. Easter is next week, okay? Easter is before the end of April. So it is impossible, unless this vessel grows wings and puts on rockets, for the vessel to arrive before Easter. And that is the kind of misinformation that I'm talking about. It can't possibly arrive before Easter. It's arriving at the end of April, just for the record. Next week is Holy Thursday. Next week Friday is Good Friday. And Easter Sunday is in approximately 9 days' time. At which time the vessel should be arriving in Hawaii. Okay?
And on that note, we end today's media conference. Thank you very much for being here, and we do wish you a productive rest of the day. Good day.